We'll get ready to start in a couple minutes. Thank you. Good morning. My name is Blaine Tamaki, and I am the co-chair of this convention from Washington State. I have the honor of introducing the Master of Ceremonies today, Paul Luvera. Paul missed last year's convention for one of the few times in the last couple decades, and we missed him dearly. It makes us appreciate and savor every opportunity we have to listen to Paul. Since it would take hours to list all of his accomplishments, and it would make us feel totally inadequate if I did that, and add to Bill Barton's therapy bill, I decided that instead of doing that today, we would try to show Paul how much we appreciate the impact he's had on us as young lawyers, sometimes middle-aged practitioners, but a lot of us have had the opportunity to listen to Paul at CLEs over the years. I am now 30 years into the practice, and I remember first seeing Paul in my second year of practice. And I was absolutely mesmerized and amazed at how charismatic and dynamic Paul was as a speaker. And so this morning, instead of just doing a traditional introduction, I wanted you to just answer a few questions for me, just take a couple minutes. How many of you have never heard Paul Luvera speak before? Please raise your hand. Okay, there you go, Paul. Virgin ears for you. And how many of you obviously have heard Paul speak before? And how many of you who have heard him speak before thought he was great?
Don't do the next one.
And how many of you, because this is even more important, Paul, and I want you to note this, because you make an impact. How many of you think you became a better lawyer after listening to Paul Luvera speak? Raise your hand, please. And how many of you were inspired and excited to be a trial lawyer after hearing Paul Luvera speak? Raise your hand. Paul, if you've ever wondered whether your time at this convention makes a difference, it truly does. And it's mirrored by those eyes looking at you today. You inspire us, you teach us, you've led us, you help us help thousands who need our help. We missed you last year, Paul, and we welcome you back. Bill Barton yesterday said, Paul Luvera is the #1 trial lawyer to ever come out of the Northwest in the last 2 or 3 generations. You remember that? Well, I think 2 to 3 generations of trial lawyers is about the history of Washington State and Northwest jurisprudence. So, Paul, you are indeed one of our own, an icon, someone that we treasure. Thank you, and again, welcome back. Ladies and gentlemen, Paul Luvera.
Thank you. Very kind of you, thank you. I love those compulsory examinations. Thank you very much.
My congratulations to the outgoing presidents of Oregon and Washington, my friend Mark, and the incoming for Washington, Becky Rowe. And thanks to Blaine and Loretta for chairing this particular section. You know, the seminar is really misnamed. I've told the story before, but I owe it to say it again. When this thing first started many years ago, I got a call from my dear friend Paul Strittmatter, who's one of the state's finest trial lawyers. And Paul said to me, who was president of the state organization, he said, I'd like to do something different at the convention. I want to do a seminar where there are people talking for 10 minutes, and I'd like you to moderate it. And I said, that's a really silly idea. 10 minutes, ridiculous, I don't think so. And he said, I'm thinking of naming it the Luvera Seminar. And I said, what a brilliant idea, Paul. And so this is really the Strittmatter Seminar, not mine. As you know, speakers, you have 10 minutes for your talk. And you will receive a warning at 2 minutes and 5 minutes. And then the buzzer goes off. I understand my friend Paul, who ran this for me last year, was benevolent. Well, I'm not. So they're 10-minute talks. Now, the reason they're 10 minutes is because people's attention span is limited. You know, earlier in July, I was at the Spence Trial College in Wyoming, and we were teaching at the time direct examination, and people had all kinds of trouble focusing. They ran over. They just start talking. And in New York, my wife Lita and I flew in on Wednesday night, I guess it was, in New York. We were at the Inner Circle of Advocates Convention. And what struck me there was the majority of speakers extended past the deadline they had been given to speak. They didn't have the discipline. What we have to be in today's world is interesting and disciplined with regard to our time. So, by the way, I should also mention my friend Claire is not here for the first time. She's always run this thing for me. And Gerhardt, thank you for all your work. Also, I did not pick any of the speakers. I give somebody else that job, and thank you for all those who found the speakers for us this morning. So those are the ground rules. If you're a speaker, come on up before you speak, give your talk, and then I'm throwing you off the stage. You can't stay. Okay? What else should I say? I think that's about it. The first speaker is Christiana McKinnon, who graduated from the Idaho College of Law in 2005, where she was on the Idaho Law Review. She's tried over a dozen cases to verdict. She's been named the Ready to Soar New Member of the Year by the Washington State Association for Justice. She's been named a Washington Superstar, Rising Star. She lives in Richland. She has a 4-year-old son, and she's going to talk to us about why I'm terrified at trial. Christiane.
Good morning. If you have ever been up at 3 a.m. the night before trial, looking over motions in limine and jury instructions, and realized at about 3 a.m. that you've spent 10 minutes on your opening statement, and you say a silent prayer to yourself that tomorrow goes slowly, you know the terror of trial. If, on the other hand, you've been up till 3 in the morning, preparing what you think is the most visual, the most amazing, the most impactful PowerPoint anyone has ever seen to use in your opening, only to find on the morning of trial that, in fact, all of your visuals have to be deleted, you know the terror that is trial. If, like me, you've had the unfortunate luck of being in front of a judge who asks you to write him a Post-it note when you need to leave to get an Advil from the courtroom for your migraine headache, you know the terror that is trial. If on the third day of trial you go home to find out your house is 92 degrees because your air conditioning has failed in the summer and you failed to notice it, you know the terror of trial. This is my son, he's 4, he's in all of my PowerPoints. And if In the middle of trial, you get a phone call from your babysitter saying that, in fact, you have to go to the urgent care facility because your little one may, in fact, have a concussion from falling at the splash park. You know the terror that is balancing your life between trial and your personal life. Terror. We know what it is. We feel it. We sense it. I love the picture of this guy. I thought about changing the name of my talk this morning from Why I'm Terrified by Trial to Why I'm Terrified to Talk at Suncadia in front of all of you. I felt like that guy. I am not this guy. This is John Wayne. John Wayne is calm, cool, and collected. When John Wayne is in trial, and we all know a John Wayne somewhere, I'm not John Wayne. He never brings a knife to a gunfight. He never brings a gun to a knife fight. He's constantly calm, cool, and collected. He never gets mad. He gets even, right? That's not me. I'm happy to tell you that I am this guy. I am Michael J. Fox in Back to the Future when I'm in trial. I'm trying to have Biff not beat me up, and I don't really understand why he's trying to. I'm the good guy, right? And I want you to know I painstakingly found every picture of James Bond from every generation that I could. I'm not James Bond in trial, and we all know a James Bond trial lawyer. They're in the courthouse. They have a license to kill, okay? I am not a secret agent. If I'm a secret agent, I am Special Agent Oso. If you have a 4-year-old, you know who this is, okay? I have 3 simple steps to teach my son to tie his shoes, to frost a cake, and I'm here to tell you that there are 3 things about terror that I'm going to be honest with you about. Being terrified about trial, I've been practicing for 7 years, and I've tried 14 trials. It's panic-inducing. It's genuine and it's real. And no matter who you read, whether you read Rick Friedman or you read Jerry Spence, the honesty of being a trial lawyer is about admitting and having the authenticity and credibility to be honest about your terror. We all feel it. It's rational. Everything that we have and our clients have at trial is on the line. It's their livelihood, it's their life, it's our money, it's our reputation. If you're not a little terrified by trial, I'm a little worried about you. Because trial, for me, it's a rational thing to be scared of, and it helps. I believe in the notion, my dad used to say that parenting was 1 part fear and 2 parts love. Now, whether or not I believe that's true in parenting, I do for trying cases. There's a healthy level of respect that the fear of the process brings, at least for me. This is a chart about whole brain creativity. And one of the things that I believe is that the goal of all of us as trial lawyers should be to reach that state of whole brain creativity, where it is that we can impact our jury and those who are listening to us in general, including the judge, by showing them that we can use all the parts of who we are, that we can use the creative side of us, that we can use the organized side of us, and that we can pick people for our team who embody both, who help us to achieve that state of whole brain creativity. And the fear that we have is actually, it's part of that reptilian mind. Our mind, the triune model of the brain is like this. And our reptile mind is the most pre-evolutionary. It's primal. And our fear comes from that place. And as trial lawyers, we spend a ton of time talking about what it is that our jury thinks. How do we get to that reptilian state of mind in our jury? But we don't spend a lot of time thinking about how do we get out of it? How do we achieve a higher state of thinking? How do we move from C, the gut reaction, the fight or flight? How do we move into D and A, the models that help us use our cerebral cortex to have a deeper level of understanding? And for me, the answer is simply this: be prepared, organized, detailed, and visualize it. Think about it, see it, go in the courtroom. For me, watch myself do it, see it happen before it occurs, and then the fear is easier to put in place. It's not that it's ever gone. It's that we do things and we take steps to learn to handle the fear. Build a team. And again, my team involves my law partner, who is very different than I am. I'm more detailed and organized. He's a big picture thinker. He is the guy who draws cartoons that he uses to impeach witnesses on an overhead projector. Okay? He thinks very differently than I do. But together, we think that our styles complement each other, and so we can achieve a state of this whole brain creativity. How do we think completely differently? And what do? We create a plan. A plan so that we can take, some of fear comes from unpredictability. The unpredictability that tells us that tells us that we don't know what's going to happen next. It's the fight or flight. And so part of our plan is creating predictability by knowing who is doing which witness. And that doesn't mean micromanaging. In the trials that we have, there's not a first chair and a second chair. We have certain roles, and we don't micromanage those roles. We trust that the other person is going to do the cross-exam the way that they'll do it, and that it will be awesome and unique to that person's model and that person's form of creativity. We love our client. And I think this is really important. And this took me several trials to understand. I was a prosecutor first. And when I was a prosecutor, it's easy to win when you're a prosecutor. You have great witnesses. They all wear uniforms, right? When you switch to doing something else and you actually have a client, you have to learn to love your client. And if you can't love your client, even when it's hard, then you can't represent your client. And so what does this mean? For me, loving my client means going to their house. It means having dinner with them. It means riding in their car, learning the things about them that make them the people that are deserving of this verdict. Know your case. Know your case. This, for me, this is more than just on page 17, line 9 of the deposition of the defendant. There's this great line I'm going to impeach the heck out of him with. That's not what I mean. For some of you who know me, my 83-year-old grandmother, who's a very conservative Baptist and religious, is one of the people that I run all my cases through because I know that she's reflective of a lot of the people on my jury in Eastern Washington. And so I like to know my case well enough that I can explain it to my 83-year-old grandma and that she will tell me, hey, that kind of makes sense to me. I understand that. I want to know my case well enough that in a sentence I can tell my 4-year-old little boy. I had a case where a tree fell on a lady who was in her car at a stop sign. And my son asked me the day I was taking the deposition of the homeowners, Mommy, what did you do today? And I wanted to be able to tell him in one sentence, well, I took the deposition of people that owned a tree that was in bad shape and it fell on a lady as she sat at a stop sign. And my son went, no, that's terrible. I mean, that's how you have to know your case. All of the details in my mind are for summary judgment motions and motions in limine. But when you're at trial, it's about the story. It's about the narrative. It's about the power decision makers in our jury who are sitting there and listening to us. And how do we appeal to them? We don't waste precious energy. We realize that in this war of ideas that we're all in, as Jerry Spence calls them, it's a war of ideas. We're battling for the minds of these people, that we don't waste our precious energy. We don't object to every issue. We pick our battles. It's an emotional, it's a psychological, and it's a physical struggle. And so we save our energy, and we know that at the end of the day, if you're like me and you go home, and you have your 4-year-old and your family, and you're making dinner and doing baths and all these things, it keeps us in a state of what's real and what matters. And we have to survive this process because it's a war of ideas. It's not just one battle. And I tried a case 2.5 weeks ago, and I was defensed. And it was painful. And I'm still in that grieving process. And loss is going to happen. And for me, you lose a lot, especially in the beginning. Out of my 14 trials, I've lost 4 of them. That's part of the process. And for me, learning to deal with that process, learning, as a very good friend told me, to feel it and then put it away, is part of what makes us trial lawyers. It's about honesty. It's about saving the currency that is credibility and using it in a way that works for your clients and for you, and for being honored to serve in this profession that we all serve in. So, in the words of Mark Twain, courage is resistance to fear. It's not the absence of it. It's mastery of it. It's not the absence of it. And so I'm honored to tell you that I am panicked by trial. I'm terrified by it. And I keep doing it, and I hope that you will too.
Don't go away. Stay here. That was masterful. I really am impressed with your poise. You didn't look terrified to me. I was very impressed. Who has questions? So, I have a question. Is there some ritual you go through to prepare yourself for trial?
There is actually. I have several. Those who know me know I'm a little bit OCD about things. One of the things that I do is on the morning of trial, I listen to the same Eminem rap song every morning. I hate to tell you that, but I do. My son knows I'm in trial when I play it. I have odd idiosyncrasies like that for me sort of calm the fear. And they cause me to have predictability even in the routine of the day. I eat lunch at the same place. I tend to do things the same way. I like my trial notebook in the exact same order. It calms the fear.
Oh, I have this question. Are you able to try your cases in your head, play a movie, anticipate the witness? Are you able to do that?
Well, I'm able to do it. It's not always accurate.
Yeah.
The way it plays out in my head, I always hope is the way it plays out in real life, but a lot of times it isn't. But particularly for opening statement and closing argument, yes, I try to see it. I try to practice it aloud,
Do you?
15 or 16 times, sometimes to my grandmother and my son and my mom and dad, and sometimes just in my mind over and over and over again until I feel like I know what it is I'm going to say.
Yeah, I try to picture my jury selection process, which I enjoy thoroughly, and objections, and I see the objection in my mind, and I say, what am I going to do? How am I going to act? And I see the other lawyer objecting to everything, and I play in my mind. I rehearse it, and it's been very helpful for me because I see these very visually, and that's helped me, not be surprised when it happens. Yeah. Well, you did a great job. Thank you so much. I met John Colati in New York. He was taken into the inner circle of advocates as a new member from Oregon. This organization is limited to no more than 100 plaintiffs' attorneys in the United States, generally regarded as the finest trial lawyers in the United States. And when you look at John, you'll see he is young. And I think he's one of the younger members we've ever taken into the organization. And so I am delighted to see him here. He is going to be talking today about lessons learned from preparing and trying cases involving medical devices. He's listed in the best lawyers in America. He's ranked among the top 10 Oregon lawyers. He is top 10 of Portland's best lawyers by the Portland Monthly Magazine. He was named Best Lawyer of the Year in 2012 in product liability. He's a member of ABOTA, the Oregon State Trial Lawyers, Washington State Association for Justice, and so on. He served as a professor of advanced trial advocacy at Lewis and Clark. But most of all, I think I like John's passion. I believe that most of our communication is nonverbal, and one of the things jurors evaluate us on is passion. And John has passion, and I know you're going to enjoy him.
Thank you. Make sure this is working. Thank you, sir. Following Paul's admonition about time frames, you'll find that I probably have the shortest attention span of anyone in this room, and usually try to use less than the allocated time to talk. The major difference between traditional products cases and medical device cases is FDA approval. And the stamp or moniker of FDA approval is actually pretty misleading to most folks, even doctors for that matter, because to many it seems to indicate the sign of true safety testing and reason analysis pre-marketing. But in reality, it's frankly no more effective than compliance with the federal motor vehicle safety standards. When we traditionally approach products, where design engineers are supposed to use what I call the design 101 or safety hierarchy, which is you're supposed to engage in a reasoned analysis, hazard analysis. And as part of that process, engineers are supposed to consider foreseeable uses and misuses. They're supposed to do safety testing. They're supposed to do literature studies. And the thing that was shocking to me as I got involved in my first medical device case is that's not required under the FDA. They have what is called the 510K process, which is a process by which 90% of all products that are on the market were approved by the FDA. And as opposed to engaging in a reasoned, disciplined, organized approach to safety through traditional design safety, the FDA allows manufacturers to seek and obtain approval simply by showing that there is a product that is already on the market that is substantially equivalent to the product that they're marketing. And that is, it is intended for the same uses or similar uses and has the same or similar design. The problem with this is, first of all, the manufacturer does not have to prove or convince the FDA that it is, in fact, substantially equivalent. In fact, they need only notify the FDA within 90 days of marketing that this is their intent. And I think we all recognize the staffing limitations of the FDA. It's up to the FDA to catch any discrepancies or deficiencies as it relates to the substantial equivalence of the product. So what happens is the vast majority of the time you've got products that are stamped as FDA approved even though there's been no recent analysis of any sort. And as an example, if there's not a device already on the market, the manufacturer has to engage in what's called pre-marketing analysis, which is a very reasoned, disciplined, organized safety analysis wherein they have to do studies, they have to do testing, they have to do animal studies and things of that nature to seek approval. With a pre-market analysis, on average, it takes the FDA 1,200 man-hours to review the literature and study materials to confirm that it's safe. With a 510K process, on average, it's 20 hours. So that's how limited the analysis is by the product or by the FDA prior to stamping it for approval. How does this play out in the real world? And this is really the lessons learned. Shocking to me, I got involved in my first medical device 2 years ago. And we saw devices that were stamped as FDA approval, with FDA approval, without any FDA approval at all. What's even more disturbing is the ability for manufacturers to engage in very, I call them fast and loose descriptions of the intended use of the product. And in general, what they will do is seek very broad approval by the FDA, and I'm going to give you an example, and then actually market it for very specific uses, which the FDA didn't even contemplate. And the problem is, when they approach a doctor, they're not allowed to market a product that has not been FDA approved to a doctor. The doctor assumes, simply because there is a staff member from a medical device or a salesperson from a medical device manufacturer in their office, that that product has been reviewed for safety and was in fact approved by the FDA when it wasn't. As an example, you will frequently see, and I'm going to talk specifically about pain pumps for a second, you will specifically see language for intended use, such as general surgery or intraoperative site. And then you would see the manufacturer actually go out and specifically market that product and device for orthopedic surgery or cardiac surgery or brain surgery or spinal surgery, when all they had was very loose language from the FDA for general surgery or quote-unquote intraoperative site. So what you see is manufacturers engaging in wordplay with the FDA simply for the purposes of marketing and profit, when in reality the doctors who are responsible for deciding whether or not a product should be used for an off-label use are the ones that are stuck in the middle. Because what happens is, once the manufacturer gets caught in the wordplay, they blame the doctor. They say, well, doctor, we only had approval for general surgery. Why are you using that in the brain? Why are you using that in a spine? The doctor, of course, says, well, I was trained that you can't come to market to me without approval. If I'm going to follow what you'd like me to do, every time I walk in an operating room, I'm going to have to look for the mark of approval on literally thousands of devices in every operating room. It's a relationship of trust. The doctors trust the companies. They trust the sales staff. And unfortunately, there's a severe betrayal out there. All I would ask that you do is the next time you look at a case, look very closely at it. If you're not familiar with medical device cases, speak with somebody who is, because there are a lot of games that go on, unfortunately at the cost of patient safety. That's all I have.
You're not getting away that easy. Questions? Well, I've handled, oh yes, sir, Nelson.
I was just going to ask, how do you determine what the actual FDA process has been for a particular product?
How do you determine what the actual, I have to repeat the question, actual FDA approval was for the product?
What their process was before they...
Thank you.
How do you go about finding that out, whether it's 1,200 hours?
Well, you seek all the documents. I mean, you look at how they, first of all, you look at the type of device it is, and this is going to, I didn't get into a lot of detail simply because time limitations. But depending on the type of the device, you simply ask the manufacturer and the FDA for all the documentation surrounding the approval process, and you'll see. But most products were simply the 510K. With a pre-market analysis, which is very detailed, the manufacturer will proudly show you that. They would be more than happy to demonstrate that, but most of them don't do it.
I was going to say, having handled these cases, they are huge document cases. You had the first successful case against a pain pump manufacturer. What did you find in terms of document control and being swamped with paper and so on?
Well, luckily, there were some folks that had blazed that trail before I did, just in terms of the document production. But it's overwhelming. Hundreds of thousands of documents, none of which said anything that was relevant because they'd done no safety analysis or testing anyway. It truly is just an attempt to bury you in a sea of paper, often which is totally irrelevant to your case.
Yeah, but you don't have a large law firm. How did you handle it?
I talked to people that knew, and I do it all myself. So my Thanksgiving involved about 16 bankers' boxes on our dining room table and me going through every one of them, looking for literally, I think, 25 exhibits is what we tried the case using.
Basic research indicates that only about 20% of the available information you have is really relevant for a trial and necessary for a trial. We continually swamp jurors with the other 80% that's unnecessary. Did you find key documents that you relied on?
We did, and unfortunately the judge excluded most of them. But there are a few out there, and a lot of it is connecting the dots. It's not one smoking gun, it's 5 guns, 3 of which are smoking, and trying to tie them together.
Other questions? Thank you, John. A very nice job.
Oh, sorry, Paul, there was a question back there.
Absolutely.
As far as the training that the doctors go on to the manufacturer, is that something that can be used to show the manufacturers in Canada how the device was supposed to be used?
Well, yes and no. I mean, the reality is anytime you market to a physician, they assume approval. So if you're going to a neurosurgeon, they assume you have neurological or neurosurgical approval, and vice versa.
Thanks, John. Appreciate it. Hello, Mark. Congratulations. You're out. You're done. Where's Becky? Where's Becky? Anyway, Becky, congratulations. You know, the Lord's Prayer only has 66 words, and the Gettysburg Address is only 286 words. And the Declaration of Independence is only 1,322 words. Now, if you look at the IRS code, you'll see the comparison between things that are profound that can be said simply and things that need to be beat to death. And so I'm always pleased when I hear speakers, as I've heard so far this morning, who are able to give us information in a disciplined and good way. Elizabeth Quick is going to talk about IME, a good offense can be the best defense. And can I start off with a complaint, Liz? There is nowhere in Civil Rule 26 or any of the civil rules that uses the word independent. Why do we keep using the defense word independent? It is a non-voluntary CR 35 exam. Okay, now that I've disciplined the speaker. Anyway, sorry, I've already, she was here earlier setting up, and I did my best to upset her at that time, and so I wasn't through yet, Liz. She's a plaintiff, she does personal injury and wrongful death law. Her firm also handles consumer bankruptcy and debt-related matters. She has a communications degree and political science degree from the University of Washington. Good for you. A JD from the New England Law in Boston. She's admitted both in Massachusetts and in Washington State. And she has served on the Board of Governors since 2010. And I'm going to really be easy on Elizabeth, who's now going to speak to us.
Good morning, everyone. Thank you, Paul. You weren't that hard on me. I heard, and I can take it.
Okay.
And I'll start off by saying I appreciate your criticism, because that's part of the one of the subtopics of my discussion, so I will get to that as far as the use of the term independent medical exam. I don't like it either, and we shouldn't like it. Civil Rule 35. This is the rule that allows the defense to seek a conditional examination of our clients, a physical medical exam or a mental medical exam. Seek a conditional exam. And the seeking part is important, and I want to talk about this, because it's not a compulsory exam. It's not an absolute right to an exam. It's something they have to work for, and the defense has to show that they're entitled to have the exam. My title was kind of pitching this presentation in terms of something of a sports analogy, offense. And I think it's important that we kind of think about going on the offense on this rule. We need to police it, and we need to be the ones who are the gatekeepers of our clients' personal information, of their bodies. And I think we need to take a tough stance on this. And I do that myself, and I want to propose to you that you think of doing that too, rather than being passive and allowing these exams, or allowing them without conditions and all the strict conditions that are provided for in the rule. So, the language of the rule itself. And I'm just going to go through this as quickly as I can, because I do want to respect the time and try and get through this within 10 minutes. I know I must. When the mental or physical condition of a party is in controversy, the court may order the party to submit to a physical examination by a physician, or a mental examination by a physician or a psychologist. And that may word is important. It's not automatic. The order may be made only on motion for good cause shown. The defense must file a motion if we want them to. We don't have to agree to the exam unless we think it's in our interest, or it's going to be an automatic exam that's granted by the court if we go through all those motions. And in that case, we talk about using a stipulation that includes all of the conditions we feel are justified and are important under the rule. And I'll get to some of those. The motion for the order for good cause also shall specify the time, place, manner, and conditions and scope of the examination, and the person or person who's going to be doing the exam. All of these are important. If they're not in there, it should be denied. The party being examined may have a representative present who may observe but not interfere with or obstruct the examination. And this is extremely important. This is something that I think about and consider the idea of not having somebody at an exam like this, physical or a mental exam, my goodness, a mental exam, and not having a representative there who knows what to watch for, or who can document or record the exam. That would, to me, would be like having our clients go into deposition unrepresented, unattended. How many of us would even consider doing that? And how many of us would even consider leaving the room of a deposition with our clients sitting there with the defense attorney? I don't think many. I don't think that's a common practice. And I equate that with letting our clients go to an exam by a doctor who's chosen by the defense, not a doctor who has any kind of a relationship with the patient or has their best interests at heart, to intrusively and invasively set up the defense and perhaps inhibit your ability to effectively cross-examine that examiner later without a record. So I urge you to have a representative there, whether it's a nurse consultant or even just a videographer. Unless otherwise ordered by the court, the party being examined or the representative may make an audio tape recording. That's in our rule. I'm sorry, Oregon. I don't think it's in your rule. I took a quick look at your rule. I knew I didn't have a whole lot of time to do a comparison of the distinctions, but I don't believe that's in your rule. It's in Washington, and we should enforce that. We should use it, take advantage of it. A videotape recording a videotape recording may be made on agreement of the parties, again, or by order of the court. Let's ask for it. Demand it. Put it in our motion if we're making if we're moving, or put it in our opposing papers. We want that. We don't always want it, and it can be a case-by-case evaluation, depending on what your circumstances are in your case, or depending on perhaps who the examiner is. Some practitioners think that a video sometimes makes the doctor be more careful, more thorough, and maybe that we don't want that. I frankly want that. I want that. I want him to know he's on tape and he's being recorded, and I want him to be fair as possible. Thank you. So the purpose of the rule. The premise of the rule was to create a level playing field, to allow the defense to have a chance to examine the claimant for the damages they're claiming. Is that a fair idea? Well, I think it is. I think it's debatable. I think there are lots of things we could say about that, and I think it's debatable, but basically, I think it's fair. We have the right to have a treating physician testify. We have the right to have our own experts testify who've examined the plaintiff. So it is a fair idea in my estimation, in my opinion. Is it effective? Is the rule effective at leveling the playing field? That's when I question it sometimes, and when we see these biased examiners come in and do what they do. Not all of them, I don't know. Everyone I've seen has been pretty biased and pretty unfair, and I want to hold out the hope that maybe someone has had a better experience where they've had a wonderful IME, a good positive result, and a seemingly unbiased examiner, but so far I have yet to see that. I have more often seen playing fields that look a little bit like this after the exam, or after the Patrick Bays or the Barbara Jessen, or I like to call her Babs, comes into the courtroom and does what they do. So, defense requests a medical exam. What next? Lose the word independent. Don't call it an independent medical exam, but let the defense do that. Let the defense put that in their papers and their pleadings, and allow you to be able to drag that out later in trial and show the jury and polarize, and let the jury understand how not independent the exam is, but that the defense likes to call it that, and cast some doubt on their credibility. My preference is not to use IME, and while it might have been titled that way, that wasn't my choice, but my preference is to not even use insurance medical exam, and I know that's something that's maybe a common alternative. The reason I like to use defense medical exam is really more of a practical thing, and it's because when we have our papers or our pleadings in trial and we want to use them as exhibits, I don't like to have to redact that insurance word and have that then read medical exam. I'd like to have it say defense medical exam, up and bold, this big on the screen. So it's really just a practical choice to call it a defense medical exam for me. Second, let's keep our minds understanding that this is an adversarial discovery tool. I'm starting to talk a little faster now because I know my time. I'm more than halfway through and I've really got to hustle. It's fraught with potential for abuse if left unchecked. There is no doctor-patient relationship created. There's no trust. There's no reasonable expectation that there's going to be honesty or fair play. And typically we will have a biased examiner. So I'd like to play a little video clip giving you an example of a doctor-patient relationship, one where we might have trust and expectation of fairness, and I hope you enjoy it.
Welcome to this malpractice educational update. Most experts now agree that doctors can reduce malpractice suits by discussing medical errors openly with patients and their families. In this case example, we examine such an event. Hi, Mrs. Smith.
Hi, doctor.
Yeah, I'm the surgeon. Your grandfather has had a tough time with the surgery.
Oh,
Well,
my.
there was a little bit of a medical mistake.
What,
Yeah.
a mistake?
Things were going well in the operation, and my nurse, she's such a joker. She surprised me with a Nerf gun,
oh,
and
my.
she just started firing away, and I had to duck down behind the heart-lung machine. But
Oh, dear.
fortunately, I was prepared. I had brought my own Nerf gun, and so I was getting ready to shoot it out with her, and so I jumped up, and my foot hit that tube going to your grandfather's heart.
Oh, my
and,
goodness.
it
Oh,
did
dear.
kind of go splat against the wall, but we were able to get it and pick it up off the floor and dust it off and get it back into him, and I think we got all the parts back into him
Is
okay.
that normal?
Yeah,
that can't be
I know.
normal
Yeah.
procedure, is it?
Yeah,
A
I know.
Nerf gun?
Yeah.
That doesn't...
But I think he's pretty sick.
Oh, dear.
But we're gonna do the best we can.
Nerf gun? That doesn't sound very professional.
We'll
dear.
keep in touch with you, okay?
This is terrible.
Yeah.
Oh, my.
Okay. I think you will agree that this doctor's complete and honest discussion of such an unfortunate medical mistake will help maintain the integrity of the physician-patient relationship. Thank you. This has been another Malpractice Educational Update.
All right, so I took some liberties. That wasn't the best example of an honest doctor-patient relationship, but I think you get the point, and I hope you enjoyed that. I had to work that in somehow.
I want you to finish.
Okay, thank you, Paul.
Because I abused you, you get
Oh, you're so sweet. So, seriously, and all kidding aside, case-specific determination. I think we should handle these cases all on a case-by-case basis. There shouldn't be any rules as to whether we're going to agree with stipulations or oppose one of these requests for a CR 35 exam. Approaches. Get on the phone. Call the defense attorney. When they ask for an exam, ask them some questions. What are they seeking? Who are they going to use? Are they going to use one of our favorites? Or are they going to use somebody who's so bad they're good? And maybe you want that. Maybe you want to have one of these bad actors come in. Maybe you're prepared, right? And you want to polarize, and you want to take advantage. So ask some questions. Maybe you haven't decided yet whether you're going to oppose it. Document your position with letters, lots of them, polite ones. Show the court later when you put those letters in your pleadings that you've been cooperative, that you've been following the rules. Ask the defense for what their position is as to can they substantiate good cause? We have to have, in controversy, we always have that, right? What's their good cause? Do they really have it? Have them put it in their letter. Or if they don't, they're on the phone, reiterate it back to them what they said in your letter confirming their lack of good cause, and then get that in your opposing pleadings. Try and shoot these down. If you want to shoot them down, we can do it. If you're going to agree to it, propose a stipulated order with all of the conditions. Representative present, time frame. You want that report sooner than the rule says you get it. You want it sooner. You want the exam done right away. Tell them all the stipulations you want. Have them agree to those. If they don't agree to those, go to court. Either move yourself or oppose their motion when they do. And when they do move, I like to put that same stipulated order into a proposed order. Just convert it and have it be the proposed order granting the exam. Only it has all these stipulations. The judge or commissioner, hopefully, will have you talk with the defense counsel, agree to what you do agree to and don't agree to, and hopefully you'll get your order granted, and that's what you wanted in the first place. Paul is scooting out, and
I'm
I'm
scooting
moving
out.
along.
That's my signal.
So when to oppose the CR 35 exam? Many reasons. Plaintiff's injuries have fully resolved. Opposing counsel seeks the psych exam where we really just have mental anguish, not serious psychological harm. Opposing counsel seeks a voc rehab exam, although watch out, in the federal rule, they're probably going to get it. Practitioner, they've chosen somebody from the wrong specialty. Don't agree to it. Opposing counsel proposes multiple exams. Don't agree to them unless you absolutely have to. Opposing counsel seeks the exam at the final hour. That's not good cause. Insufficient grounds, and so forth. All of this is in my materials. I hope you'll have a chance to read it because the details are there. I guess my ultimate desire and request is that everybody try and think about this as something that we have the responsibility to police. not the judges and the commissioners. We can do it in a proactive way, and we can be effective at doing it. Thank you.
Thank you. Thank you, Liz. Don't go away. I'm getting soft in my old age, Liz. Questions? Yes, sir.
Just going to say, one thing that we require is the stipulation, say what the examiner's going to charge per hour for his deposition and limit it to something that's $500 an hour, something high, but not astronomical. That way, at the end, you don't find out you got to pay $1,500.
Sure.
Go back to court and argue about it.
Thank you. It's a good idea. Yes, Karen. Karen, my courageous trial lawyer, the warrior right here. Karen, yes.
When I was a younger lawyer and I worked for Tom Chambers, he used to have oral argument on every single motion. There was not a single week that I wasn't forced to go down and argue against a CR35 exam. He wouldn't allow us to ever agree to them. And I've gotten a little lazy in my old age. I've got these lovely stipulations, I agreed to them, but he wrote an opinion, which was a dissent, which slammed CR35 exams, and it's very eloquent. I have it in the brief. I think if you don't have it, I have it.
Let me interrupt a minute. What she's saying is she has a brief on CR35, and you're going to offer it, right?
From Chambers, and after hearing this, it reminds me, I don't know why I ever stopped filing those motions. I think I'm going to start filing them again.
Karen's saying that she should object more often to CR35. If you think about a CR35, I'm sorry, Liz. Any comment about that?
Oh, no, I think she's right on. I'd love to
Make
see
sure you're
that.
by the microphone, though. Okay.
Yeah.
If you think about a CR35, and we have to move on, this is not a doctor that your doctor asked to examine the patient, asked for a consultation. It's not a doctor that your client, your injured person said, I need to see a doctor, this is the one I'm going to choose. This is someone who has never met this individual before this day. And what happens when the exam is over? They get paid. And what happens at trial? They come and they testify. And then what happens? Doctor, when you're through testifying here, you're going to walk out that door with your fee, and whatever happens to Joe here will have nothing to do with you. If you're completely wrong, it won't make any difference to anybody except Joe, but it won't make any difference to you. And so we need to emphasize, I think, the fact that this is an exam which is far from being independent and is something that we should be objecting to more. I agree with that. Thank you so much. Oh, I'm sorry, yes?
I have a quick question, Liz. So what always worries me about this, because at the end in my mind is always the trial, is if you bring this motion and you win, how does it look in trial if you want to go there saying, my client was the open book, they had all the medical records, we saw the doctor you wanted, if their response can be actually, you didn't want me to see that doctor, and I didn't get to see the patient, I only got to review their records, that always really worries me.
Okay.
Have you had to deal with that at trial?
I haven't had to deal with that.
Did anybody hear the question?
Yeah.
Did everybody hear the question? Question is, what if you object and you don't let the exam take place? Then at trial, you're exposed because you kept the other side from having that opportunity. Roughly that.
And I have had that come up because I have brought motions precluding, and what I've done is filed a motion in limine making sure that the defense does not get up and whine like that, and it's been granted. I've been fortunate to have that granted, so that's how I've approached it.
J.D. Smith, get your bones up here. Thank you very much. Massachusetts, huh, Liz? Here's to good old Boston, the land of the bean and the cod, where the cabots speak only to the lodges and the lodges speak only to God. It's one of my favorite. This is J.D. Smith, and he's going to talk about balancing the load, tips for reducing stress in your law practice. He's worked both as a claims adjuster in his past life and an underwriter. He's tried 35 civil cases to verdict and completed over 50 arbitrations. He's been in the ABA House of Delegates. He's a former president of the Young Lawyers Division. He's served 6 terms on the Lawrence Smith Bar Association Board of Directors, and he's served in a number of community activities. And so we're all going to learn how to balance our life. J.D.
Good morning. It's my privilege to be here. Coming to this convention is always comforting because we have so much in common. Meaning, how many times have we come here after a great victory, and there's other people who've had a great victory, but on the flip side of it, how many times have we come here and things are not going well? We've just lost a case, we got fired by a client, or just life in general is not going well. And you find that someone else is similarly situated, and maybe they share with you what they did to get better. I was reminded of something I used to think about a lot early in my career. I used to always think, was Jack Connolly always Jack Connolly? Was Paul Luvera always Paul Luvera? Was Paul Strittmatter always Paul Strittmatter? And as you learn about each of their careers, early in their careers, things weren't always so perfect like you think. You think that they get the good cases, everything goes well. It looks like it goes well, but when you know them and you learn their stories, their struggles are just as similar as ours. Now, let me, I said that because I brought that up because I was thinking about Karen Kohler, and I've seen the process, and that sort of hit home that these people are not always, Jack wasn't always Jack, but Karen, we've seen this process. We've seen how she is so brave to even come all the way out here and try cases, and I admire that. I get, encouragement from people like Karen, who are bold enough to not only go out and try cases, but to tell us about the great ones and the ones that don't go so well. So Karen, I admire you, and I appreciate the insight that you give us. It's so incredible to see what goes on in your mind and how you're able to make a difference for our clients. So thank you very much, and congratulations. You pulled off a victory here. That's a huge accomplishment. When I tried a case out in Yakima and I lost, my friend said, "What the hell were you doing in Yakima?" And I'm like, "Oh, I thought I could win," And I learned that there's so few victories, especially in those kind of cases, medical negligence cases. Now let me turn for a moment and tell you why I picked this topic. I speak substantively all the time about rules and ethics and trial and things like that. But I picked this topic because I was almost overcome with stress. And I didn't even know it. I didn't know that I was stressed. I thought I'm in fairly good shape. I work out. I eat okay. But last year I tried 7 cases. I was pushing about 125 caseload. And I went home one day and I couldn't sleep. And I knew something was wrong. It didn't feel right, and I started having a pain in my chest. And I was smart enough to go to the hospital because I almost just shrugged it off. And I went into the hospital, and one of the worst things that I think that they can tell you when you're having a heart attack is that you're having a heart attack. Because as I went to a local hospital, and they had to take me by ambulance to a bigger hospital, and I overheard them talking, and I'm saying to myself, how could I have a heart attack? How in the world could I have a heart attack? I mean, I'm not even 45 years old yet. How could I be having a heart attack? Fast forward, I'm back to work, and I'm sitting at a red light, going back to work, and as I'm sitting there, I see a lot of commotion in front of me. And I'm getting ahead of myself. Well, the doctor told me that the reason for my heart attack was stress, and my blood pressure had shot up, and I never had an issue with blood pressure before. So the reason I decided to pick this topic was to illustrate that we have to do a better job of taking care of ourselves. That's why I'm bringing this up. And it's over the years I've learned that's one of the things to help is to get it out, to talk about things. I wasn't talking about the things that weren't going well in my life before I had the heart attack. But I'm sitting at the red light, and there's a bunch of commotion in front of me, and a tow truck driver was towing a truck up Madison, and I was sitting at third, and he somehow, he was going the wrong way, and a van that he was towing came off of the truck and came barreling down the hill. And the commotion in front of me was telling me to get out of the way. Now I'm driving a fairly big sized truck at the time, and all of a sudden I played football in high school, and I felt like one of the worst hits that you can imagine, like going over the middle. Will can relate to this. And it's like you're blindsided. Well, this tow truck, this van hit me and knocked me all the way in the intersection. And as I'm standing there, I feel pain going down my leg. I had a disc herniation, and I had to have back surgery. So that was last year. And my sister said, I think somebody's trying to tell you something. So let me talk to you. Paul, how much time is on the panel today? I missed the very beginning.
Well, I'm interested, so I'm going to give you a little extra time
Okay.
here.
Well, here are some of the signs that that you may not even know that was upon me. Indecisiveness, poor judgment, inability to make decisions, difficulty concentrating, lack of assertiveness, irritability, depression, loss of sense of humor, fatigue, use of alcohol, anxiousness, and sometimes physical symptoms like headaches, chest pains, nausea, high blood pressure, tiredness, sleeplessness. Those are some of the signs. If you have any of those, then you might want to look at your stress level and then figure out how can you deal with it, or some way. So again, I hate to use myself, but let me tell you how I've been dealing with it, and I'm not by any means where I think I should be. I still have a long way to go. But I had to stop working as many hours. Throughout my career, I've worked 70 plus hours a week. And what I've learned is that when you scale it back and you realize, okay, I'm going to leave at 5 no matter what, you become more productive, because you know, if you're like me, I used to just think, well, I could work until 9 or 10. And so that means you drift off and you take social phone calls, or you play on the internet. So cut back the hours. That's one thing that I did. Here's the biggest thing that I think was my mistake, and that is learning to say no to cases. I used to think that I could just take on every case possible, and also limit practice areas. I think that's a big thing that we can do. And meaning, if you're good at auto cases, just take auto cases. But then if you do get a good medical negligence case or a slip and fall, then maybe you consider associating those particular cases, because we have so many great lawyers in Washington that we can go and associate. I had an opportunity to work with Matt, and that was a great learning experience. Matt and Gavi on a case that I was way over my heels with, and those guys came in and really helped me. Thank you very much, Matt. One of the other things is I started doing yoga, and I started working out with a trainer. And one of the things that my doctor told me is that if I put it on my calendar, and he says, if you can go out and do all these great things for your clients, then you can make certain commitments to yourself. So I started putting my training on my calendar in the same way that you wouldn't miss a deposition. I decided if I have a trainer, then I'm paying for it, so I can't miss that appointment, because otherwise I'm wasting money. So that was one of the things I did, and I started doing yoga. And then here was the most important thing that I thought I would never do, and that was I started counseling. And the reason I never thought I would do counseling is because I've read so many medical records about how our clients have poured out their souls and they're told their counselors the truth. And then, and that's what came to mind to me when I got hit in my car accident. I was thinking, oh, shoots, got clear liability. Now they're gonna know all my stuff. But, I figured, what, because of what we do, we've seen so much, you realize, okay, I could deal with my stuff, because we've seen our clients. Okay. One other thing that I think that you can think about when managing stress is that you don't have to make an overall change. It's not like you have to go in and change everything tomorrow, but you can pick some things that you do have control over and change those small things so that it doesn't seem so overwhelming. Opening up to someone, you don't necessarily have to go to a counselor, but open up to friends or colleagues, because once you do that, you realize that you do have more in common. My friend Thad Martin and I were both having a difficult time, and Thad has such a great sense of humor. When he found out I had a heart attack, here was the message from Thad. Yo, dog, you can't die. Fat people supposed to die first. How you gonna die? What I'm gonna do without you? Regarding the caseload, that's probably the biggest thing that I can tell you is to go back and look at your cases, and if necessary, get rid of a few cases. We've all had those clients that are very difficult, and you feel like, for me, one of the pressures I used to feel about getting rid of a client is I was embarrassed about, I don't want another lawyer to come and look at my files and see what I didn't do right, so I would just hold on to these problem clients. But now I just bring them in and say, look, this is not working out, and I feel so much better when I get rid of a problem client. Take care of yourself, trial lawyers. We're all family. I see so many faces here of lawyers that I admire and respect. And I appreciate all the wisdom that you've given me over the years. Karen was probably the biggest influence. I met her at an early CLE, and she encouraged me to follow my heart. This is when I was doing defense work. And when she told me that, my heart led me to this practice, and I'm so appreciative of that, Karen. So I'm going to leave you with this. They say that you will forget what people do. They say that you will forget what people say, but you will never forget how someone makes you feel. And trial lawyers, I feel good being here. Thank you.
No way. Ah. Good for you. I'm proud of you. Don't go away. Diogenes would have stopped here. He found an honest, truthful man. That was beautiful. You see the power of truth? You see the power. If you were in a court, look, there has never been such a group of talent, of excellence as there is in this room. Every one of you can be a great, great trial lawyer, and if you're a great, great trial lawyer now, even a better one, if you would just be you. There's only one of you in this whole universe. No one else is ever like you. And all we have to do is to be ourselves, because when we are ourselves, we project credibility. Credibility projects trustworthiness. Jurors are looking for someone to trust. I would have given him his $10 million if he'd asked for it. Because he was being truthful. What a powerful force truth is in a courtroom about everything. About how you feel, about your insecurities, about the witness who just beat up on you. It's powerful. You were beautiful. Thank you, Paul. Beautiful. Who's got a question, suggestion on better life or anything? Good work, JD. Loved it. Is that you? Okay, all right, good. Well, all right, Michelle Burrows. Practiced in Oregon since 1986, sole practitioner, God bless you. That's a dying breed. Good for you. It's courageous, too. Attorney General appointee to the Civil Forfeiture Asset Oversight Committee, which deals with racial profiling issues. Former Vice President of the Oregon Criminal Defense Lawyers Association. She's a member of the board that deals with prisoner advocates. She's been on the prison committee for Western Prison Projects. She's served on the faculty of a 6-week course on advanced civil rights litigation, and for the ACLU. And you went to the Spence College in 2007. I saw you there, didn't I? 2007. This is your course was less than 30 days, but it was a long time, right?
very long time.
It was a long time.
For
And,
sole practitioners.
right, out in the middle of nowhere. We're 2 hours, I guess, from Jackson Hole to Du Bois, and then another half an hour down the gravel road way out into the middle of nowhere where there's a ranch. And at this ranch, there's a barn. And that's where the instructions happen, and these people are kept there. It's like a cult. After a while, they're trying to escape, you know. Anyway, the good for you. That's wonderful. Graduate of that. And she's also a graduate of Bill Barton's 2010 boot camp. Everything about that is great. I'm anxious to hear you.
The title of my speech today is Turning Any Government Act into a Civil Rights Lawsuit, and it came as a joke with a conversation with Hologoris. I don't know how I can turn 150 years of litigation into 10 minutes, but I'm going to, and it's a good idea because I'm 1 week away from 3 weeks of trial, and I'm not frightened, I'm just heavily medicated. There are 4 principles that you have to know, since we're reducing this to a commercial soundbite, that a civil rights case can be brought when under color of law, a government person causes an infringement of a protected federal right or entitlement, and there are damages. These are my notes for today's speech. Each of these elements has a plethora, a lot of case law. And since we're in the Ninth Circuit, we are in the land of milk and honey. The case law in the Ninth Circuit is the best in this area of the law. But do not ignore other circuits, even though they suck. Under color of law can be any person, and that can be a municipality, but not the state, or any individual who, under their government powers or authority, and you tend to think of police officers in this instance, but it can be a code inspection officer who fails a business because they're not in compliance, or who takes a bribe to pass them, and then a nightclub fire ensues. Anybody under the color of law who then infringes on your protected civil rights, and your federal rights are found either in the Constitution or a federal statute. And the typical constitutional amendments that we look at are within the first 14. Typically the first, which is, anybody? Nobody knows? The First Amendment?
We're afraid to answer.
You're afraid to answer. It's a trick question.
That's right.
The First Amendment is the freedom of speech and assembly. We are exercising our First Amendment right to gather together today and praise each other. The Second Amendment is the gun rights entitlement, also known as the NRA Amendment. The Fourth Amendment is the one in which ensues most of the litigation, the bad cop cases, bad search, and unreasonable use of force. Those are the biggest ones. Those are the most notorious ones. Those are the sexiest ones. And unlike some of you who get too much discovery in the medical device cases, we don't get any discovery in the Fourth Amendment cases because they don't want us to know what they did. The other amendment, which gets a lot of litigation, is the Eighth Amendment, prisoner rights cases. And this one is mostly done, in large part, by pro se prisoners. And this is a very complicated and unwelcoming area of the law, but it's a very important area of the law, and it comprises about 50% of my practice right now. So if you have a government actor, and it can be a municipality, but there's special rules for that, who does something bad, a bad act, that can impute one of these amendments and the 14th Amendment, which we'll get to in a moment, and there's some harm, then you have a civil rights case. So the reason for the title is that I don't think some of us are always creative enough when we look at what the government does. The government is so embedded in our lives. There is a rule or a statute or some provision that guards almost everything we do. And those in this room, and I know a few of you, are perfectionists at mucking around with those rules. So if you have a government actor who does a bad act, and somebody gets hurt, and your gut tells you something is wrong here, It has to be something more than mere negligence. And each one of these amendments that I've talked about has a different standard. The Fourth Amendment is unreasonable. The Eighth Amendment is deliberate indifference. The 14th Amendment, which can be sort of a catch-all for procedural and substantive due process violations, is shocks the conscience. So some cases that fall under this 14th Amendment provision can include the nightclub code enforcement officer who takes a bribe and there's a bad fire. You might get into a problem where the municipality says, well, we're not going to indemnify that crook, he's in prison. Then you have to get creative and figuring out how to go after the municipality under a Monell claim. But that's beyond my 10 minutes at this point. But you have to have some bad act that rises to a level above mere negligence. And I think many times we can prove it. We can do it. It's just a matter of being creative. Now, why would you do this? Why in the world would you take a nice, easy negligence case, and why would you turn it into a civil rights case? There are no tort damage claim limits, and there are attorney fees. You can get declaratory injunctive relief, and you can make positive, effective, proactive change in the way the government does its business. And you can't always do that in a negligence case. In the area of damages, the other thing that can be both a pain and a pleasure is that you don't actually have to have out-of-pocket losses to get to the jury. Now, sometimes they call these nominal damages if the jury says they violated his rights, but he wasn't really hurt by it. And sometimes you can have what the Ninth Circuit has called presumed damages. You can get money just because the Constitution has been violated. But ironically, you have to prove some emotional impact, some non-economic loss to yourself. Now, I have a lot more time left. I'm pretty much done with my little condensed version. I do teach this in much longer version, but here's my pitch to you. I know a lot of you personally, and I know of some of you, and there is a talented group of litigators in this room. This is a very important area of the law, and it has been so much more important since 9/11 and a lot of the Patriot Act type legislation. It is very, very important that we do this. It is one of the only safeguards that we have to keep our government in check. If you get a case in, and in your gut you know something's wrong, call me. I will give you 27 years of lost legal research, work, briefing. I will talk to you on the phone, and I will do it for free. Thank you very much.
Don't go away. So the reality is you're doing the Lord's work.
Yes.
Yes. There's not a lot.
Praise
Here's
the Lord.
Right.
And the Constitution.
Here's my problem before I ask for questions. Isn't your litigation in federal court for the most part?
You can do it in state and federal, but I go to federal.
And if you're suing a police officer for violence, unnecessary force, the usual motion is for summary judgment on qualified immunity.
And there's an immediate interlocutory appeal, yes.
You stole my line.
I'm sorry.
If we're gonna do this together, I have a line and you have one. That was my line.
Oh, shame.
And there's the right to immediate appeal.
Correct.
Of that summary judgment, which means that as a matter of course in every one of these cases where you're suing the policeman and the summary judgment goes against the policeman, they appeal because they want that delay of appeal.
Mm-hmm. Yes.
Which means these cases go on.
Forever.
Forever.
But the Lord's work is hard. With delayed reward. But the attorney fees are accruing, damn it.
That's true. That's true. And what about punitive damages? Isn't there a cause in there somewhere for punitive?
Yes, against the individual. If the individual actor acts out, you can get punitive damages.
Okay, now let me ask you this question. I've done focus studies in this field, okay, of these involving primarily policemen who shoot some poor guy for not answering yes sir or something, okay? And what I found in my focus studies, and I'm asking because what your reaction, is I found a percentage of people of about, I'm going to say like 25%, who believe that no matter what the policeman does, it's okay. They can shoot their mother, it's okay.
Yes.
Then there's a percentage of people who believe if you don't obey a cop, if the cop says, get down on all fours on your knees, I'm about to shoot you, and you don't do it, the cop can shoot you. It's okay. Then there was a fixed percentage of people who believe that if you commit any crime at all, I don't care if it's a misdemeanor, the cop has the right to shoot you or do whatever the hell he wants, right?
Yes.
Then you have this group of people.
I'm getting depressed, Paul.
Then you have a small group of people who just hate cops in general.
Absolutely.
They get kicked off the jury. And so you're dealing with all these Nazis, are you not?
Yes, you are.
So
And they're not all in Yakima either.
So what are you doing with them? I mean, you get no voir dire to speak of in federal court. What are you doing? I'm really serious, Michelle.
You go after the municipality primarily is what I'm finding, because a jury will get pissed at a cop, will get angry at a cop shop that lets cops behave this way. They may not want to go after the individual officer with the pickup truck in the driveway and the little kids, but they will go after that police department. And getting a Monell claim has been
Don't worry about it. Okay.
has been really key to a lot of the cases that I've been developing. But then there are people who will look at what police officers do and they just get offended. Shooting a naked guy running away in the back. That was one of my last shooting cases.
You had one in Oregon where the guy's on top of a car.
That's the one.
Is that the one?
Yeah, that's the one.
Yeah, well, I mean, it's just incredible. You know, not content with tasering people to death, they also like to make sure they're dead and they don't get away.
This one was shot 7 times, so he was super dead.
Yeah. Well, let me ask you this question. I hate federal court. I'll confess it to you. I go there only when drugged there, and then I still hate it. So you don't get the benefit of the Civil Rights Act in state court, that you like the punitive damages and attorney's fees?
No, you do.
Oh, you do?
You do.
Okay.
You can bring these cases in state court.
But don't they remove them?
Well, yeah, but that wasn't your first question.
Go ahead, I'll let you finish. Go ahead.
You can bring these cases in state court, and because of federal preemption on a 1983 claim, all of the federal entitlements and damages and all that stuff apply. But yes, 9 times out of 10, they remove them to federal
10
court.
times out of 10. They don't want to be in state court because they know they're going to get beat up in state court and they won't in federal. So again, you're doing the Lord's work. I don't know why you're doing it. It's wonderful. Question.
Donations at the back door? That's what started this.
Go ahead.
Hala and some good friends of mine have a case in which a TriMet bus driver, late at night, crossed over multiple lanes of traffic, plowed into 5 folks in a crosswalk, ran over 2 of those individuals twice, and badly injured a 3rd individual, and the 2 people who lived and survived were related to the dead kids and held them as they died. So there's tort claim caps in Oregon, and Hala and Rick Pope started talking to me over lunch, a very nice lunch, so I got lulled into this whole thing, about how can we deal with these tort claim caps. And I said, well, let's look at a civil rights claim. It's under color of law. It infringed upon my client's right to live or to be unharmed. It shocks the conscience what this driver did. She was convicted of some traffic violations, and we then filed federal claims in federal court while the state case is pending, and we're negotiating and doing some gamesmanship right now. But that all came about, Hala started the conversation because TriMet, the bus company, only wanted to put 1.2 million or 1 million for 2 dead young people, 1 who is survived by a child, 1 seriously injured gentleman, and 2 young people who have incredible psychological damages. And it just wasn't fair. It wasn't right.
Hold on a second. Megan, where are you? Megan Chang. Huh? I need you up here. Well, we want to be on schedule, and if you're not ready to go, I don't want to wait for you, okay? Okay, questions? Yes.
Michelle, are there times, or let me put it this way, for those of us in Washington where we don't have court caps, would there be times that you would consider filing just a state claim in order to avoid some of the problems of federal court? Or are you so enamored with what you can accomplish under 1983
Is it Megan?
that even
Is it time for the break?
Are you serious? You have no tort claim caps up here?
After.
Yeah, I don't even know if I want to talk to you. I think that if you want to make policy changes, if you want to change the way people are shot, if you want to change the way people are trained, a 1983 claim is a very good way to do that. If you don't have tort claims and you don't have some bleeding heart need to show that these cops are bad actors, I can't really think of a reason, but I am enamored. I think it's important.
I'm enamored with you, but I got to make a stop.
Okay.
You did a great job. I'm really proud of you.
Thank you.
Megan Chang is going to speak to us about what I've learned assisting senior lawyers on a high-value, complex case. I immediately hated that title because I assumed senior meant old, I'm sure, but you didn't mean that. But in any event, she was born in Hawaii, grew up in Eastern Washington, graduated summa cum laude from Walla Walla University with a degree in business administration, and went on to get her law degree cum laude from Gonzaga. And she works for my good friend Blaine. And she's an Eagle member. She served on the diversity committee. She's been very active in Big Brothers Big Sisters program. And so I'm interested to hear what you have to say about helping old lawyers.
Thank you, Paul.
He's going to take a break.
Good morning, colleagues. As Paul already mentioned, I work at Tamaki Law Offices in Eastern Washington, where we handle a diverse variety of personal injury cases, from your basic auto cases to wrongful death, government liability, over the past few years, claims stemming from child sexual abuse, medical malpractice. And I've been fortunate to have the opportunity to work with some talented lawyers on some really tough, high-value, complex cases. So I'm also fortunate this morning to be here with you to share just some of the things that I've learned from those cases. I don't anticipate that what I'm about to share with you this morning will be new to most of you. I'm just hoping to provide my perspective and perhaps some food for thought to just challenge the thinking and maybe refocus on some of the things that I found that we as attorneys don't really always find the time to do. So, over the past 4 years, the number one lesson I've learned assisting senior lawyers is that the associates do all the work. I'm sorry, Blaine, I couldn't resist. But I hope it goes without saying that the success of the firm, nor Trial Lawyer of the Year, is obtained through the work of your associates. But the lessons I have learned can be summed up in two categories: investing in your case and investing in your client. So, without further ado, the first lesson I've learned with regards to investing in your case is it starts even before a case becomes your case. How many of us have had potential clients call in or come into the office and say, "Ms. Attorney, you need to take my case because it's going to make you a lot of money because it's worth thousands of dollars." I've had that happen more times than I can count, and how many of those cases actually turn out to be worth thousands of dollars? In my experience, pretty much none of them. So the truth is that a good portion of the cases we've had in our office that have been higher value cases has come from clients that have come to our office on totally unrelated matters. And I wish I could say from good marketing that these high value cases are just delivered on a silver platter, but we know that doesn't happen. So I've found that having attorneys screen cases as opposed to staff has been an investment that's paid off for our firm time and time again. I mean, think about it. We as attorneys, we went to school to learn how to ask good questions and issue spot, and these calls are the blood of our practice, so who better to handle them? I've even seen it pay off on smaller value cases, learning from the senior lawyers in my office to screen cases. It turned what was a basic, soft tissue slip and fall injury, which are probably my least favorite types of cases to screen, into a limits auto case just by exercising some attorney intuition. So another good thing about good case screening by attorneys is that it allows for an on-the-spot evaluation of whether the facts presented have good potential. in the personal injury practice, we all know that you essentially have one call to determine, is this case something that's worth it? And I think to, entrust that to someone other than an attorney can be risky, because another thing that I've experienced in our practice is that a lot of our higher value cases have come from cases that have been overlooked or rejected by other attorneys. The second lesson I've learned about investing in your case is good organization. I hope that would go without saying, and I was absolutely stoked yesterday or Thursday to hear all the speakers talk about efficiency and organization and different software that you can use, because I can't tell you how many times I've had to reread reports or go over a whole entire file just because I failed to take the time on the spot to draft a memo or make notes. And there's nothing like a high value case that will make you kick your butt into gear and say, I need to start learning to incorporating documenting regularly into my practice. And documenting also helps in the context of good teamwork, because it allows for good communication and effective or efficient work when you have numerous people working on a case. And that's the third lesson I've learned about investing in your case, is the power of teamwork. We're fortunate to have, we're not a sole practitioner office, obviously, and having a team comprised of, staff support, and more than one attorney just enables time to be spent in areas that often get pushed to the side or have to be outsourced. And it allows for a sounding board, throughout the handling of the case, and effective brainstorming. It's allowed our office to spend more attorney time on things, case preparation, trial preparation, all those areas. One of the most fulfilling examples that I've had, or that I experienced, was when I assisted Blaine on a dram shop case. We had a key witness. He was actually an employee of the particular tavern that we were suing, and we'd set up his deposition numerous times, and he'd failed to appear. We finally got him to come to our office at least to meet with one of us, and Blaine gave me the privilege of handling that meeting. But normally, sometimes when we don't work as a team, that's something we'd have to have an investigator do. But since I was able to handle it, I was able to, on the spot, draft a declaration that was consistent, or had enough facts consistent with Faust to withstand a motion for summary judgment, and eventually help lead to the tender of the commercial policy limit on that dram shop case. So building a team, a good team, extends beyond just the staff in your office. As we all know, it also extends to experts. And I don't know whether it's time constraints or just the comfort and familiarity with working with experts that we've worked with in the past, that it almost becomes automatic to just call the expert especially on smaller value cases. There's a plethora of resources out there to search for experts, Jury Verdicts Northwest, the listserv, all those things. But I've personally enjoyed the challenge of trying to find my own experts through none other than the assistance of Google. In a recent medical malpractice case that we just took on, the particular medical injury was a stroke. And I just spent some time going on Google, looking up stroke, and led me to find a particular facility that was specialized in stroke, the Stanford Stroke Center. And I contacted them directly and was connected, with a great neurologist there who's just brilliant. And so finding my own expert, it makes you invest further in your case, and just brings a fresh perspective on the case. The fourth lesson I've learned, and probably the most powerful, is the power of good case presentation. This is something that I don't think, good case presentation can't be obtained without living your case. Christina McKinnon talked earlier about loving your clients. I explain it as, spending time, just like she did, to get to know your clients, to enable you to develop their entire story. Those of us who've been to trial lawyer college seminars, we've learned all about the art of telling your client's story. I don't know about you, but I've struggled personally to just find the time to put this into play, especially, in smaller value cases, but I've really challenged myself to just try to do it on a smaller level. So it's whether, I've really found that you tend to get caught up in I call it your attorney brain, but the side of your head that's just really analytical and strategic, and it kind of it puts up a barrier and prevents you from really asking your clients the right questions, just being present in the room, when you're there, and like Christy said, learning to love your clients. And we all know that our clients aren't good at putting into words, the loss they've suffered or the injury that they've suffered. And that's why spending that time to know their story is so important, because it's our job as their attorneys to develop that story and present it in a compelling way. So there was a particular case that we spent a lot of time on case presentation, and it was at the stage of the case of mediation. And I've seen it affect not only the defense and mediator, because it helps tell them, that you know your case and you're ready for trial, but it also impacted our clients. On the screen is an example of trial exhibits that our office worked with Diane Meyer of Legal Presentation Graphics to create. Just a short little side note, Diane is amazing. Talk about great teamwork. We gave her just tons of documents, and she was able to help compress all the information and present it in a compelling way. I actually brought one of the exhibits here in person. Maybe I'll try to put it here on the table real quick.
I think it'll stay. Finish up, go ahead.
Okay.
Go ahead.
But this gives you a much better idea of how big they were. But we had about 8 or 9 of these. It took up an entire conference room at WAMS, and I can't tell you, when the clients walked in and saw it, I mean, they were just touched and speechless. And good case presentation, I found that it helps fulfill the client's need to be understood and fought for. It builds their confidence in the attorney in more ways than just our legalese briefs or spoken words can, and it increases their trust in their attorney to allow them to really take full lead on handling their case, and that's something I found that's valuable. And that leads me to my 5th and final lesson I've learned from high-value complex cases is the value of investing in your client. Just taking the time, again, to really understand what they're going through. I try to remind myself on a daily basis that what is everyday, commonplace occurrence for me is just a terrifying and foreign experience for them. And, it's what I've seen through working closely with my clients is what, in their eyes, what can make a good attorney a great attorney is one that deliberately shows a genuine interest in their well-being from the start of the case. And even though I've struggled to do it, it's really paid off every time I've tried, and it's worth doing, because even when I'm not as successful on a case, through my attorney eyes as I'd like to be, through the human side of us, we can see that we've still made a difference. We've made an impact on our client's life, and just like that Outlast money, it makes a difference that helps make everything we do worth continuing. So thank you.
Oh, go ahead. Go ahead. Well, first of all, Megan, I owe you an apology because I didn't realize there was a break coming up, which is why you were there, not up here. So I feel like a judge who's reprimanded the wrong lawyer. Thank you, that was good. I heard a talk, where's John? We both heard a talk in New York by a woman from Texas who tries complex cases involving hormone therapy. And so she has all these complicated medical articles, and her talk was how to simplify it, and it was absolutely, for me, it was just amazing. For example, we all know the principle of anchoring. And what she did was, there were articles that were relevant and articles that weren't relevant. So she color-coded the irrelevant articles she knew they would use. And she even had in her hand a device she could slide on color. These are relevant, these aren't. She had all kinds of, she even held up a glass, 2 glasses of water. She said they were Coke. She said, this is Coke, but one of them is rum and Coke. You can't tell the difference. They look the same. It was just simple things like that, and I was just awestruck. She made Melvin Belli look like an amateur. So, presentation, I guess what I'm saying is this is truly important, doing it right. And that's a hard job. Anybody have any suggestions, questions? Okay, Blaine, where are you? I'm right here. Good job. Thank you, Megan.
Before we take our break, we need to announce that the exhibitors will be having their sheets, that you need to submit those if you've seen all the exhibitors, because this will be your last chance to submit it for the iPad raffle tonight. In addition, if you're playing golf this afternoon, the tee times have changed, so you need to check with the registration desk on your tee time to make sure that you're not late for your golf date. So with that, we're going to take a 20-minute break. It's 10:11, and we're going to take a 20-minute break. We'll be back here at 10:30, and we're ahead of schedule thanks to Paul. So so we will get out of here probably a little early. Thank you very much.